Mediation requires hiring an expensive mediator to facilitate negotiations that might lead to a voluntary settlement. It only works if all parties are willing to make significant compromises, including the party that legally deserves to win. That disposes of the case and ends the extraordinary cost, delay, and risk of public court litigation, but it does not provide a just outcome.
Rick Grossman here, founder of the nonprofit Intelligent Justice. In this post, I will explain why obtaining an enforceable decision to resolve a dispute via comprehensive adjudication is a superior procedure to resolving the dispute through mediation. Mediation is the joint retention of an expensive professional mediator to facilitate the negotiation of a voluntary settlement of the dispute. However, mediation is not a process for deciding which party legally deserves to win the dispute. In fact, no mediation is ever successful unless all parties make substantial compromises, including the party that legally deserves to win. As a result, mediation can be an effective process for ending the litigation, ending the pain, but it is not a process designed to achieve justice. In my years as a trial lawyer, I participated in dozens of mediations as legal counsel for one of the parties to the dispute. And although most mediators allow for some discussion of the merits of the dispute, those discussions are rarely helpful in reaching a settlement. Instead, mediators effectively use the extraordinary cost, delay, and risk of public court litigation to persuade each party to make the concessions necessary to reach a settlement. After a short preliminary discussion, the mediator often places the claimant and its lawyers in one room and the defendant and its lawyers in another room, so the mediator can talk privately with each side. The mediator often starts with the claimant and says, "I think you have a decent claim, and you may very well win at trial. Of course, there's always a significant risk that the judge or jury will mistakenly decide the case against you. Ask your attorneys if they will guarantee a win at trial. They can't do that. But even assuming that you might win, ask your attorneys how much that victory will cost and how long it will take to obtain a trial verdict in your favor and a final judgment after all appeals are completed. Talk that over with your attorneys while I go talk with the defendant." The mediator then goes into the other room and says to the defendant something very similar. The mediator says, "I think you have a decent defense, and you may very well win at trial. Of course, there's always a significant risk that the judge or jury will mistakenly decide the case against you. Ask your attorneys if they will guarantee a win at trial. They can't do that. But even assuming that you might win, ask your attorneys how much that victory will cost and how long it will take to obtain a trial verdict in your favor and a final judgment after all appeals are completed. Talk that over with your attorneys, and I will come back in a few minutes." After that few minutes has elapsed, the mediator goes back and forth between the rooms in an effort to mediate a settlement. And in most cases, all parties are willing to compromise their positions once they fully understand the cost, delay, and risk that a trial in public court will require. Those compromises are often enough to dispose of the case, but they do not provide justice. Comprehensive adjudication is different. It is designed to result in a just outcome after a thorough investigation by a neutral adjudicator who has expertise in the legal specialty that is relevant to the dispute. And it is designed to reach that just result in less than half the time and at less than half the cost of litigating that same dispute in public court or conventional arbitration. Of course, a settlement is possible at any time before the adjudicator decides the case. And if the parties so desire, they can even hire a mediator in an effort to facilitate the settlement negotiation. But the party that deserves to win will not be coerced to compromise its position because of the overwhelming cost, delay, and risk of public court litigation. Instead, any settlement is far more likely to reflect the merits of who actually deserves to win. In fact, the comprehensive adjudication procedure builds in a short period for the parties to discuss settlement after the adjudicator provides them with a written identification of all the evidence relevant to the adjudicator's decision, but before that decision is made. Under those circumstances, the parties can make informed decisions about the likelihood of obtaining a favorable decision and settle the case much more appropriately if they so desire. In my next post, I will explain why comprehensive adjudication is superior to conventional arbitration.